right, the City of Rollingwood, the special city council meeting for canvassing returns of the general election and bond election will come to order Tuesday, November 15th, 2022 at 6:01 p.m. And we will begin with a roll call.
Brown, present.
Alec Robinson.
Phil McDuffie.
Sarah Hudson.
Gavin Massengill. Being quorum present, we will move on to public comments. Any citizens wishing to address the city council on items not on tonight's agenda, we're happy to entertain those. That's the, you got one? Okay, we don't even have to look at the sign-in sheet. Happy to recognize you if you'll identify yourself for the record. And
Hi, I'm Bob Turner. Thank you for the opportunity. I'm a 25-year resident of 2601 Pickwick Lane. I'm a third-generation Austinite. Years ago, I served on the RCDC. I'm currently a sitting member of the BOA after serving a term as an alternate. I also serve as an officer on a number of HOA boards, which I'll get to in a minute. I'm here today to address some serious concerns and bring to your attention certain council members' actions and behaviors that, in my opinion, can only be described as overstepping their authority, using their elected position and professional standing to intimidate and influence, and interjecting legal counsel and advice when not retained in such capacity, in an apparent attempt to usurp the role of the city attorney. While I have it on good authority, this type of conduct by this individual is not unfamiliar to you all. I'm here to present the sequence of events surrounding the October 26th meeting of the BOA, which I personally experienced this egregious behavior. To remind you, there's only one matter on the agenda that evening of the 26th. It pertained to the Western Hills Athletic Club third hearing, dealing with a request to restore 2 existing tennis courts and add 2 more. At the first hearing in June of 21, all 3 variance requests were approved by a 4-1 vote. The lone dissenting vote each time was cast by said council member, who was then a member of the BOA. Shortly thereafter, the individual in question raised a technicality that public notification was not given to the entire community. Clearly, this dissenting member was not satisfied with the outcome and wanted a do-over. Well, she got her mulligan. At the second hearing, the following September, the outcome was effectively reversed when the BOA approved just 2 of the 3 requests. I understand as a result of this, a lawsuit is pending against the city, which takes us to the most recent hearing on the 26th of October. This time, the applicant applied for a special exception under section 107-491 of the zoning ordinance in order to permit the reconstruction of a non-conforming building or structure and permit the enlargement or extension of a non-conforming use or building, right from the code. Leading up to that meeting, I'm receiving normal correspondence from the city secretary, Desiree. As council members, you all know the drill. A meeting reminder, the agenda, updates to the meeting packets as they occur, all posted to the website with a link provided. Then on the afternoon before the meeting, I received correspondence which I found to be unusual. It was an email from Councilmember Brown asking Desiree to, quote, send the comments below to the members of the Board of Adjustment and copy the applicant. I found this very out of the ordinary, as every other set of public comments was either included in the meeting package or those that arrived late were read at the meeting. This was the only set sent directly to the BOA. In Ms. Brown's note to Desiree, she makes a point of saying, I'm filing these comments not as a member of the City Council, but as a concerned resident within 250 feet of the project. Wink, wink. But we all know Ms. Brown is a sitting council member, as well as the council liaison to the BOA. And for the record, her residence is not within 250 feet. Councilmember and BOA liaison Brown's 4 pages of comment go on to inform the BOA that we should not even be hearing the case. The requested special exception is not authorized under Rollingwood ordinances, quote, and how we should find concluding I would urge the application to be denied. This document is only just the beginning of how Ms. Brown abuses her role as liaison and uses her council position to attempt to intimidate and influence the BOA, which by statute is established as an independent board. Earlier I mentioned I serve on a couple of HOA boards. I have more than just cursory experience with liaisons. By definition, they're supposed to liaise, to act as a link, to assist with communication, to coordinate between groups. The email the day before and her actions at the meeting the following evening, which I'll address next, clearly go well beyond that, to the point of highly questionable and improper behavior. At the BOA meeting on the 26th, Councilmember Brown was in attendance and unabashedly signed up to speak at the public hearing. When she addressed the board, she spoke against the applicant. Her comments were a reinforcement of the note she had sent the previous day about why we should not be hearing the request, and if we do, why it should be denied. In doing so, she set out to redirect the focus away from the only real issues, those addressed in Section 107-491, special exceptions. Instead, she made it about pickleball, nuisance, noise, traffic, parking. Miss Brown's strong opinions about pickleball conveniently left out the fact that there's already been a pickleball court at that facility for over a year without any public outcry. Upon the conclusion of her comments, she still wasn't done. After starting to leave the lectern, she promptly returned and asked for additional time. Chairman O'Donnell, noting that she'd already gone well over her time, twice her allotted time, reluctantly gave her 2 more minutes. Ms. Brown's effort to raise extraneous matters left several board members with more questions than answers, exactly what she intended. At that point, the notion of tabling the matter was raised, and the board latched onto the idea. Because special exceptions are so rare, we then began to explore what was permissible and how we might proceed when the meeting was resumed. Sorry. That's when Ms. Brown, or Councilmember Brown, or Liaison Brown, or Barrister Brown, I'm so confused by the number of hats this woman wears, stood up and asked to speak and proceeded to counsel the board. For me, this hat trick was the final straw. I asked for clarification from the, in fact, city attorney. The ensuing advice from the city attorney was vastly different from what the unsolicited direction we had just received from Ms. Brown. No, another public hearing was not required, but it was an option available to us if we wanted. All that I have related, her email and actions at the meeting, are public record. I encourage you not to just take my word for it, but go read and look at the videotape. Despite Ms. Brown's express statements that she's only acting as a concerned citizen, she is a current city council member, as well as an attorney, attempting to impose her will, not only on the BOA, but on the city attorney, in a thinly veiled attempt to sway the results in a manner which she chooses. I don't know which hat Ms. Brown thinks she was wearing at the hearing on the 26th, but in my opinion, she cannot pick and choose. My ask is that you censure her, adopt a formal statement that this council will not tolerate such behavior. As a sitting council member, Ms. Brown should not be able to intimidate and attempt to influence the independent BOA. As the council liaison to the BOA, Ms. Brown should be doing her job and liaising. And again, not attempting to influence the outcome of an independent board. As an attorney who is not the city attorney, Ms. Brown should not be giving instructions to the BOA on how they should act and how they can act legally. As Ms. Brown clearly cannot separate her own role, one role from another, I ask the council do so for her and provide clear direction to her on the limits of her authority. Thank you for your time and your consideration.
Thank you, Mr. Turner. being with us this evening. It's not on the agenda, so there's no opportunity for back and forth, but thank you for being here.
Appreciate the opportunity.
All right, with that, council, we will move on to, well, no, we won't. We will not move on to agenda item number 2 and 3, and I just want to kind of bring you up to speed. At this time, unfortunately, the election results from Travis County are not available. These returns are obviously necessary for us to conduct the regular order of business here as items posted for discussion and possible action this evening. A recess to the following regular business day that is taken in good faith and is meant to not circumvent the Open Meetings Act is authorized by section or by Chapter 551 of the Texas Government Code is permissible. And with that in mind, members, I would ask you to consider a motion to recess until November 16th at 6 p.m.
Mr.
Well,
Mayor,
I was gonna say, I'm happy to make a motion to that effect, but if we make a motion to that effect and we approve it, then we have to show up at 6 o'clock even if we don't get the data tomorrow?
If you'll make that motion, and hopefully you'll have a second, I'll tell you a little bit more of what we have in store.
Okay, I move that the city council recess until November 16th, 2022 at 6 p.m.
Heard the motion. Is there a second?
Second.
You heard the motion and by Ms. Hudson and a second by Mr. McDuffie. So we have noticed this thing five ways to Sunday, literally. So the intent would be, we believe, staff has had multiple conversations with the county. And just so you all know, we were informed that we would have them by today and this evening, which is why we moved forward with this meeting and posted it properly. We got word yesterday late that that was not going to be a possibility. So we moved quickly yesterday to post for Thursday
and Friday.
Friday.
As of
So we have, because we have to have it done by Monday. So we have multiple postings in play. We believe, though, based on conversations that were had today, that we should have them by tomorrow. And with that in mind, it would be better for us to be able to canvass these votes so that we can seat new council member tomorrow if possible. So with that in mind, this is our latest, greatest idea to get us to tomorrow. If we do get those results, official results tomorrow, then we can canvass at 6 tomorrow and continue with our evening the way we had planned. If we do not, for some reason, then our backup plans are Thursday, which I will not be able to be in attendance for, or Friday in a worst case scenario. If we say get to tomorrow or the next day and continue to have some problems, we could even have a discussion about Sunday or Monday, but hopefully that won't be necessary. So we've got sort of 3 contingency plans in place right now, but the most likely scenario is that we will get them tomorrow and we will be able to canvass the votes at 6 before tomorrow's official meeting. So if you were to adopt this motion to recess, again, it's just a recess, so technically this meeting continues on until tomorrow. Then we would come back in. We would come back in after the recess and do our business in this meeting tomorrow, and then we would adjourn that meeting and then start a fresh meeting at 7 o'clock posting.
Right. So if we don't get the information tomorrow, we still have to show up at 6 o'clock. Because we will have called a meeting for 6 o'clock.
Well, no,
Or
you
we
could
will
get here
know
at
it.
7. So if that happened, if we didn't have it, you could just get here at 7. We would immediately come back into this meeting, close this meeting, and
Okay.
go into the next meeting. Yeah.
I'm just trying to figure out
Understood.
when we have to show up.
Understood.
Based on what we're doing here.
Fingers crossed, knock on wood, show up at 6. But we will let you know well before 6 if we do not believe that that's going to be an option. And then
You let us know.
Ashley will email you.
I'll email. I'm also happy to call in
yeah.
case it gets last minute.
Yeah.
Another good note, though, for canvassing is we really only need 2 council members to canvass the election. That's some special section of the act that allows that. So if it came down to it and we could only get a couple people, we'd be okay. But of course, we'd love to have you all here. So.
Yes. And if it does go into Thursday or Friday, you'll be on your own because I can't make it. So, but hopefully that won't happen. So, any other discussion, questions, comments?
Well, if it were to go to Thursday and Friday, are we still going to figure out who's mayor pro tem?
No, the thought would be if we have to go to one of those days, we would not be able to seat the new council member. So my thought would be that we would probably push all of that to December.
Okay.
I mean, it's your prerogative to do it as you wish, but my thought would be that you would probably want to wait till you have a full council.
Right, and then, so the sitting mayor pro tem would still remain the
Yeah.
pro tem, so she'd be running the meeting, that's what I was getting.
Yes. Yeah.
Okay,
I
great.
haven't thought about that. So I'm still on council until I replace myself?
Yes, as I am still, and I'm still the mayor until I replace myself. So we're in an okay spot, but on that note, too, Councilwoman, so Roxanne would continue her tenure until her replacement is seated next month. Okay. You've heard the motion. You heard the second. I will call a record vote. Councilwoman Brown.
Aye.
Councilman Robinson.
Aye.
Mr. McDuffie.
Aye.
Ms. Hudson.
Aye.
Being 4 ayes, no nays, motion to recess carries.
All right.
We will enjoy the rest of your meeting and we'll take a 24-hour break.